It's the dreaded podcast divorce. What happens if you and your co-host stop agreeing on the show's direction? Who keeps the name? Who owns the back catalog? And can one of you keep publishing under the same feed without the other's ongoing consent? A lot of podcasters think that they can just take a walk, and that misconception is what turns creative differences into costly fights. So today I'm going to show you how to end a podcast partnership the right way, so you protect the show, the audience, and yourselves. I'm Gordon Firemark, the podcast lawyer, and this is Legit Podcast Pro. You know, partnerships can be powerful, but they can also fall apart. In this episode, you'll learn why breaks happen, what the law says about ownership, the exact steps to a clean exit, and how to prevent a messy split before it starts. But before we dive in, just a quick note. I go a lot deeper into this inside my Easy Legal for Podcasters program, so you can check out a link to that in the description. And if you need ready-to-use co-host agreements, exit templates, those kinds of things, I will point you to those as well in the description and at the end of the show. So it's a sad fact, but podcast partnerships do break down. People have different visions. One host wants to do more interviews, the other wants to do more narrative, or someone wants to go true crime and the other wants to do comedy. Or there's an uneven workload. Someone's doing all the booking, editing, and socials, and the other's just sort of showing up to record. Or maybe it's the money. New ad dollars, affiliate sales, live events, who gets what? And time and life can get in the way. Someone gets a new job, a move, a baby, a burnout, who knows what, and it changes the dynamic. So here's a hypothetical scenario. You've got a two-host show with about 100 episodes in the can. One episode wants to pivot to true crime. The other wants to stay in the business space to sell their coaching. And they both claim that the brand is theirs. Well, we're going to resolve that in a minute. So I'm going to walk you through a simple decision tree that tells you sort of who keeps what and how to end it without blowing up the brand. So start off by determining who already owns what. This is the ownership audit or the asset audit. Think about this in buckets and make a list while you're listening and watching to this. Okay, 1, is there a trademark registration that protects the name and the branding of the show? Who owns it? Is it owned by an LLC or an individual? If there's no registration, then who was the one who started using it first? If it was both of you, that's hard, but if one person started, then it makes the case a little easier. Who has controlled the brand assets from the beginning? Next up, ask about your back catalog, the copyrights. Each episode you've made is a copyrighted work. If you are both joint authors of it, then you may be joint owners unless there's a clear written understanding about who's supposed to own things. You're looking for that work made for hire clause. And then there are the scripts and the show notes and the artwork and the music. Who created those things? Were they work made for hire, or were they assigned and transferred or licensed to the enterprise? Next up, whose account controls the feed, the RSS feed? That's your audience, right? So this is the house and kids stuff. Who controls the Apple Podcasts and Spotify dashboards? Who controls the domains, the socials, the email list? Who registered it? Who holds the logins? Who owns the list and the privacy promises that were made to subscribers when they joined the list? What about the deals, sponsorship and network agreements, revenue shares, insertion orders, affiliate accounts? What do those things say about termination and make goods? And then there's the cash, money in the bank, the PayPal, the Stripe, you know. Who controls that purse? What accounting is required for the revenue and the expenses? The rule of thumb is this: if the show is owned by an entity, then that entity likely owns all of the intellectual property and all of the accounts. But if there is no entity and there's no written contracts, then you might have a troublesome situation of joint authorship and joint ownership. It's messy, but it can be fixed with a good separation agreement. So you've done the audit. Now you choose a path. What's the form of the exit going to look like? Is one host going to continue and one leaves? That's sort of an assignment and buyout where the remaining host gets to keep the name, the feed, the catalog, and the departing host signs everything over in exchange for some form of compensation. That buyout structure can take a lot of different forms, but some of the common ones are just a fixed dollar amount or a fixed dollar amount paid over a period of time. It could be a percentage of revenue for a certain number of months or years. It could be a combination, a hybrid of those, where there's a small cash payment plus a trailing revenue share that gets capped at some point. So that's one model. Another model is where both start fresh and they just retire the brand of the old show. Just put a sunset date on things. The name and the feed are going to go away after a certain amount of time. During that time frame, you both use it to promote your new shows to each other and to your audience. And then each host launches their own new show with new branding and so on. And maybe there's some licensing for limited use of the back catalog clips for promos and things like that if you want. A third model is the spin-off and coexistence, where the original show continues with host A while host B launches a new show. And in the coexistence agreement, there are terms about clear naming rights and no confusion and disparagement and so on. A fourth model is to sell or license the brand to a third-party entity, or maybe to the staying host. This should include rules about quality control, reversion terms, and licensing and things like that. And then there's the promise that we're offering here. In a couple of minutes, I'm going to show you the checklist of documents that you want to make any of these paths actually work. So here's a step-by-step process for that clean break. First off, start with a private conversation where you align on the principles of fairness, speed, audience continuity, integrity, reputational protection, those kinds of things. Then exchange a one-page term sheet that outlines who's going to keep the name, the feed, the back catalog, the rights, the money, the timing, the communications plan, all those things. And do a closing checklist that makes sure you have all the items that you're going to need to transfer: logins, domains, hosting, analytics, and accounts. And then updating the Apple and the Spotify and the YouTube channel and all those, the manager platforms for those things. And changing the bank access. You're going to remove the former partners from any password managers and make sure that they no longer have access to the things that are sensitive. Back up your catalog and metadata, and then notify the counterparties in any contracts. These are your sponsors, networks, affiliates, guests who have episodes that haven't been released yet, all of that. And make sure you honor any obligations to make good. If you have unfulfilled promises, get them fulfilled one way or the other. Clarify who's responsible for the future obligations. Then it's okay to make a public announcement. Be brief, be respectful. It should be a united message. No finger pointing, no blame naming, and no drama. Then reassure your listeners about what's next and what to expect and where to follow each of the hosts going forward. Now it's time for the tech transition. Redirecting the feed, setting the 301 or platform redirect the right way is very important. Update your show art, descriptions, websites, and social bios. This is going to take some time. Next up, the money. Settling up without a fight. Agree on a revenue and expense cutoff date. Maybe it's the end of the last full month or the end of the calendar year or something like that. Then pull a cash basis profit and loss statement and make sure you're looking at all the ad revenue, membership, merch, affiliates, minus any real out-of-pocket expenses. Again, identify any obligations for any unfulfilled promises to advertisers, missed mid-rolls, event appearances, those kinds of things. And then choose a schedule for the payouts. Maybe it's 25% now and the remainder over 3 or 4 monthly installments. And decide what's going to happen and who receives any evergreen ad revenue for trailing income, late affiliate payments, things like that. And it's okay, put a cap or a sunset clause on that so that you're not endlessly on ongoing accounting obligation. And then there should be a simple audit clause that allows for a reasonable review of the other side's books if there's something that looks hinky. Next up, communications plan that will help to preserve the brand and the goodwill. Make sure you say to the audience that you're grateful for their listenership and that the show is going to continue or not, and where to find the new hosts. Point to the new feeds and the newsletters, and confirm any sponsor ad deliveries, make goods, contracts, W-9s, 1099s to make sure that the right people are doing the payments and getting paid going forward. Likewise with your production team, editors, writers, virtual assistants. They should know who they're now to report to and under what contract terms. If you have to, rewrite those contracts, rehire them. Maybe you want to include a non-disparagement and confidentiality clause in writing, because one spicy social post can really tank both brands. It's just not good for your reputation. It's not a good look to be bad-mouthing your former co-host. Next up, what are the documents that you're actually going to need? Here's your checklist. You need a separation and termination agreement of some sort. This is the master document. And then it has exhibits attached to it that address the transfers of any intellectual property. These are called assignment agreements. Trademark registrations, trademark applications, copyrights, domain names, handles, artwork, show notes, and episodes, all of that. Any licenses that are needed, like that, let's say there's music or artwork that you've been using, limited rights to use archive clips or the brand during the wind down period. And then you need the mutual release language. This is the legal clause that essentially sets everybody off on a clean slate. Very important. And again, that non-disparagement and confidentiality will keep everything civil and buttoned up. And then be sure to list all of the accounts and make sure that the new owner has all of the access and control that they need in writing. And then finally work out the payment schedule. What are the installments going to look like? Are there going to be late fees or set-offs, or maybe money's going into an escrow to be held until certain milestones are achieved? And of course, if you have guests and music paperwork and things like that, make sure that the usage rights allow for the new setups, whatever they may be. Sponsorship amendments. You're going to want to update those contracts. Make sure you have clear descriptions of who's supposed to get paid and when and what the delivery obligations. And listen, this is a pro tip for you. If you have a network or ad rep that uses the we pay when we get paid model, make sure you require some reasonable efforts to actually collect, and make sure there's a payment timeline that's tied to delivery so that you get paid not later than a particular length of time after the ads are performed on, in a published episode, those kinds of things. Avoiding disasters. What can you do to watch out for this? What are the real world risk points? Well, one risk is lockouts. Be careful that nobody is going to change passwords until the deal is signed, right? Nobody should be using the DMCA to weaponize takedowns or resolve catalog ownership. That should be handled in writing first. Likewise, sabotage by omission. If you forget to, in quotes, redirect your feeds, or forget to give the logins over, or whatever. Make sure there's an access schedule that gives the right people the right access to things to make sure it's working the way it's supposed to. Likewise, orphan contracts. Get rid of that old hosting plan, the Zapier account, the Calendly, the premium plugins that are still charging the cards that were shared by the group, right? Get rid of all that and start with a fresh, clean slate if possible. Now, when talks stall, you need to have sort of an idea about how to escalate. First off, it's always a good idea to just let everybody cool off. Just take a week or two. It's not going to be the end of the world. And if necessary, find a facilitator, someone who can, by agreement of the parties, can step in and just get you talking again in a calm, respectful way. Next up, if that doesn't work or you can't make a decision about that, then mediation. Mediation tends to be faster than litigation. It's private, it's relatively cost effective, and it's a great way to resolve disputes. But if you don't get through mediation with a resolution, your last resort is going to be arbitration or litigation. So expect months and months of time and real expense associated with that. And of course, one thing you can do if someone is harming the brand, passing off the association, hijacking the feed, deleting accounts, those kinds of things, is you can go into court and get a restraining order to prevent that kind of thing while the other resolution is still pending. All right. How can you prevent these kinds of problems on your next collaboration? This is where the podcast prenup really shines. Bake it into your co-host agreement from day one. Make sure it states who owns the name, the logo, the catalog, the entity, or the individuals, who gets decision-making on tiebreaker rights, who is responsible for what duties and what time contributions. What about the money? How are the splits going to be handled? Reimbursements, approvals, thresholds, things like that. What about who gets to decide what guests and sponsors and controversial topics the show might cover? What about leaving versus firing? Notice, cure, and cause, right? What's valid cause to make someone leave? What's valid cause for someone to leave by choice? Then there's the buy-sell formula. What's the pricing going to look like? Is there a fixed price, a multiple of the revenue from the prior year, a trailing royalty, or what we call a Texas shootout, or sometimes a Russian roulette kind of a model? And then there's the question of who gets to use the archive after the end of the relationship, and the non-disparagement and confidentiality clauses, as well as be sure you address what happens in the case of death or disability. What's the continuity plan in that circumstance? Do you want to be in business with a deceased partner's former host, a former spouse, or something like that? Probably not. So that's something to be thinking about as well. And payment timelines. As I said before, don't accept that we pay when we get paid limit. without actually putting limits on it and timeframes. Set it up once and you will save yourself from lots of headaches later on. So if you had to part ways today, do you think you know who would keep the name and the feed and all of those assets? If not sure, then it's time to pay attention to these action steps. Do that ownership audit right away. Doesn't have to be because there's a dispute. It's just a good idea to have an index of all of the assets. That's the podcast name, the trademark, the catalog, the feeds, the domains, the socials, the list of all the episode content, the contracts, any cash that's on hand. Make that list and keep it updated. If you're already splitting up, then a one-page term sheet for the split up is a good idea. Get some early agreement on those terms and you can move forward with some confidence. And then use a proper separation agreement with those IP assignments. And for new and ongoing shows, start with a podcast prenup that you get signed right away. This whole process is covered inside my Easy Legal for Podcasters program, and I offer a free podcast prenup planning guide over at podcastprenup.com. Now, breaking up a podcast partnership is hard. It's no fun, believe me. Doing it the right way, though, will protect the brand, respect the audience and the hosts, and it will preserve the relationships as much as possible. So get that prenup planning guide at podcastprenup.com. And if you want the complete legal toolkit, templates, training, and all the monthly coaching, check out easylegalforpodcasters.com. I'm Gordon Firemark, the podcast lawyer. That's it for this episode. So keep on creating and keep things legit. See you next time.